Welcome, everybody, to episode 9 of We the Parents podcast. And my guest, my only returning guest so far, Mr. Dean Tong. Dean, how are you?
Hey, good evening, Chris. Thanks for having me back.
Absolutely. I think this is the best time to have you back because if we want to go ahead and let the audience know, for those who don't know, April is what month, Dean?
It's National Child Abuse Awareness and Prevention Month, the month of the child.
Okay. So when have we, getting into that, have we declared parental alienation child abuse?
In a roundabout way, it's in the DSM-5 as estrangement, child psychological abuse, child affected by parental relationship distress, and parent-child relational disorder. So it's in there as subtypes, but the word alienation is not in there, and it's not going to be in the ICD-11, which is coming out in January of next year. So I think the problem is the psychiatric and medical communities are paranoid that the word alienation intimates maliciousness, vindictiveness, that one parent is going to use this disorder as a weapon, as a tool for the purpose of gaining custody.
Well, and couldn't we argue and flip that on the head and say, well, you're using false allegations to get custody. So you can weaponize anything.
Well, sure. But when you weaponize, again, you're intimating bad faith, premeditated forethought, malice of forethought, premeditation, bad faith. You know, I'm going to pick up this phone. I'm going to call the toll-free hotline number and ruin your life by wielding my child as a pawn, weapon, or tool and accuse you of physical or sexual abuse. And you're going to be investigated, and the kid's going to be taken from you, and you might go to jail and lose your freedom and your kid in a New York minute. So that's what the psychiatric and medical communities are contemplating with this conundrum. And, you know, this is accepted in the society guidelines of both the American Academy for the Child and Adolescent Psychiatry, ACAP, AACAP.org. It's also accepted by the American Academy of Pediatrics. So it's accepted by the medical community, but it's not really accepted by the psychiatric community, which publishes our DSM-5.
Right.
So it's ironic and it's sad, but this is what we're facing. And Dr. Bill Bernay, who I'm actually working a case with, has been at this for a long time as an expert. He's out of Tennessee. He's retired, but he still lobbies the committees to try to, basically include this disorder as a recognized mental health disorder in our DSM. So it's been unsuccessful thus far, but he's keeping at it. I am at his website, which is pasg.info. Anybody who has a situation involving alienation, where your child is either rejecting you or has been estranged from you by a falsely accusing parent or a parent that you're in a custody battle with, I suggest you go to that website, pasg.info. Anybody who's anything is over there at that website. I have a page over there as well.
And go ahead and tell me what that website is. And while you're talking, I want to pull it up for everybody too.
Yeah, it's the Parental Alienation Study Group, pasg.info.
.info. Okay. I'll pull that up. Now, Dean, why don't you tell us, I've heard a few people mention that they feel that parental alienation is junk science, that it's not substantial, that it's just, like you said earlier, used as a tactic for abusive parents to claim that the other person's being abusive. So, you know, obviously you've been doing this a very long time, and it's not necessarily fully recognized in the psychological realm, but give us your opinion on that in 30 plus years of dealing with child abuse and parental alienation.
Well, you know, science is governed by case law in court. So in your state of North Carolina, the law that governs admissibility of science and expert testimony is called Daubert, Daubert. North Carolina is a Daubert state, and that means any scientific theory that a judge, as the gatekeeper of the science, is going to rule on, whether it's junk science or bona fide, genuine science, that scientific theory has to be peer reviewed. It has to be published. It has to have a known error rate. It has to be scientifically reliable. Um, and it has to be accepted by the general psychological community, which is the Fry standard. So all of those factors have to be met, and a judge has to decide that when an expert is going through what's called voir dire, which is tendering his or her credentials and qualifications, and then is going to be giving findings and opinions on whether alienation, whether the case is consistent with parental alienation or not. To be honest with you, only a judge can rule on the credibility of witnesses or a jury if it's a criminal case. And only the trier of fact, the judge or the jury, can rule on the ultimate issue at bar. So if the ultimate issue at bar is parental alienation, then a judge has to decide if it's alienation or not. That's up to the judge. It's not up to me.
Right.
It's not up to Dr. Jones or Dr. Smith or Mary Lou, licensed clinical social worker therapist. It is up to the judge. The judge determines all that.
So, what is your opinion when you're dealing with a judge who deals in legality, not psychology, not science, not anything in that realm of mental health?
I mean, you're seeing this play out in real time on CNN or whatever stations are carrying the Derek Chauvin trial in Minnesota, the cop who's accused of killing George Floyd, right? Leaning on his neck for 9.5 minutes. And so multiple experts have testified in that case. So Minnesota is actually an easier state to get scientific evidence in. The law there is called the Fry-Mac standard. That's not as stringent and strict as the standard in your state and my state, which is Daubert.
Right.
So it's all up to the judge. The judge determines if this is BS science or if this is real science. And it could be anything. It could be fingerprinting. It could be parental alienation. It could be you've been accused of molesting your kid, and I'm sending you for sexual deviancy testing, psychosexual testing. Is that real science or is that junk science? It's all up to the judge.
Do we need, in your opinion, do we need judges to handle these things, or we should change family law and leave them in the criminal realm?
I don't think so. I don't think we need to go that far. I think judges need to get further education, in this stuff, and I think there needs to be more seminars and webinars that judges can attend to be, to get the knowledge that they need to be able to rule on this stuff correctly. So a lot of this is not rocket science,
right?
But it does get technical. It does get complex, And
now,
and
does the system allow it to get messy though? Do you feel like a lot of things are cut and dry, and that the system lets it get deeper than it even needs to without any evidence? I mean, how many rights are violated, even in my own case, where we haven't even done anything? And there's no burden, there's no evidence, there's no nothing.
Well, that could be just savvy attorneys against you who are trying to impeach the credibility of you, as the respondent, who are trying to impeach the credibility of your fact and expert witnesses. All that is good lawyering. I mean, a lawyer's not going to wave the white flag. They're going to litigate.
Sure.
And they're going to pull any trick in the book, so you don't receive the equity at law you're seeking.
Right. Well, and when you say that's good lawyering, in my opinion, and I'm fairly new to this, only a few years in, it's not good lawyering. There is no, in my instance, it's all been avoidance. No one's gone after me. It's just been dodging me. It's been avoiding me. It's not, I can't have my kids, but if I seek my children, then they'll tell me why I can't have my kids. It makes no sense. So where is the common sense in the family law courts? Because there doesn't seem to be any. That's been my experience.
Right. Did I lose you there?
You might have frozen for a sec, but I can still hear you.
Okay.
But I did lose you. So while Dean is probably going to sign back on here in a second, if you guys have any questions, There's Dean. Oh, lost Dean. You should be able to request a jury of your peers. Yeah, we talk about that a lot with having. There you go. Dean's back. Dean, turn your camera.
Okay, there we
There you
go.
go. Yeah, you're back. Bobby Burke said that you should be able to request a jury of your peers. Why don't we have juries in civil
Well,
matters?
yeah, so there are only a few. Well, there's only one state in America where you get a jury in a child custody case, and that's the state of Texas.
Uh
That's
huh.
it. One out of 50. In
Wow.
juvenile court, where your kids could be taken from you for the rest of your life, and you could be TPR'd. That exists, I believe, in Colorado and perhaps Maryland. I mean, there's only a few states where you get a jury trial there. So these are mainly cases like in my state of Florida, it's trial by judge. So child custody and dependency for abuse and neglect allegations, it's trial by judge. Again, the judge decides
Right.
whether the child is going to be adjudicated dependent, which means by statute the child's has been abused, neglected, or abandoned.
Hmm.
So you get two shots there. You can either consent to dependency, which basically means you did wrong. You abused, neglected, or abandoned the kid, and you're going to jump through their hoops just to
Right.
get your kid back because you didn't have the money to hire perhaps a dream team to fight this,
Right.
or you're going to go to trial. Take your pick.
Right.
I can assure you the last dependency trial that I went to, it was very protracted. It lasted 4 months. The government spent, I don't know, $300,000 to try to terminate my client's rights, which was the mother, and she was accused of coaching her kid to false accuse the dad of incest.
Oh.
So those cases are clearly David versus Goliath, where the
Hmm.
accused is David, obviously, and there's 15 people on the government side of the bench, CPS, and 3 people on your side,
Right.
you and your expert and your lawyer, and that's it.
What do we need to do? The whole thing. You've been doing this so long. What what do we need to change in the way we handle family law, child abuse allegations, parental alienation? What would
Well,
be your solutions if you could snap your finger?
yeah. So the first thing that needs to be changed um, is the mindset that children don't lie. Children are not mistaken about sexual assault, for example, and must be believed and protected at all costs. So the system works what's called in loco parentis parens patriae. The state
Right.
is the parent. The state is the parent.
Right.
So immediately, if this is a tennis match, advantage government coming in, you're at the disadvantage. So you have to build your credibility as the trial ensues and proceeds, while you're impeaching the credibility of the child who's against you, and perhaps the mother or whoever the parent is behind the child. So it's a very tilted system out of the gate,
Right.
and that's because of the rules on hearsay. Okay, so hearsay by definition is an out of court statement made for the truth of the matter asserted. Generally speaking, hearsay is legally inadmissible.
Right.
Not so in a child abuse case. It's Rule 803 for the most part, which means it represents the exception to the hearsay rule. So if a child tells a doctor or a counselor, "My daddy touched my pee-pee," that mandated reporter is going to call it in, and it's going to come into evidence on the record as the exception to the hearsay rule. Now, you can retain my services as an expert. If you don't have the resources to do so, you can try to go through the judge who would go through the state to pay my fees. But my job is to see whether the child was spontaneous, reliable, and trustworthy by looking at the child's forensic interview on DVD, the CPS records, the police records, if there are any, the Child Advocacy Center report, any other reports that would be material, doctor's notes, therapist notes, or if the child is tainted, contaminated, and adulterated. Perhaps the child was coached. Okay,
Right.
perhaps the child was triggered, and maybe the child was mistakenly pointing the finger at dad when it was John down the street that molested the kid. So you
Right.
got the wrong guy, mistaken identity.
Right.
Or perhaps it didn't happen. It was just a figment of the child's imagination. Maybe you were tickling the kid, and and that tickle became a sexual touch.
But yeah,
Obviously, the sexual allegation is the one allegation that's going to raise the eyebrows of the court. It's going to raise the eyebrows of the jury. I mean, we're seeing this in real time with the football quarterback from the Houston Texans, Deshaun Watson. I think he's
yeah,
been charged with like 21 or 22 lawsuits for sexual harassment, and and those are adult women. But imagine when it's a child, a minor under the age of 18, immediately all eyebrows go up. That, oh my God, that's a monster. That is heinous. That's reprehensible. He must have done that. If the child said he did it,
right,
why would the child be lying? Well, usually it's not a lie. Usually it's not a lie. Usually it's a source misattribution error where the kid or the system is making a mistake. And I'm
right.
not saying it's not. I'm not saying the cases don't happen, because they do, but only 1 in 20, 5% have medical findings, according to the American Academy of Pediatrics. So only 5% are going to show positive mental trauma, okay, upon rape exam. So the rest are going to be hearsay. The rest are going to be he said, she said, what a child said, and that's most of the cases that come across my plate.
Dean, how suggestible and coachable is a child?
Very. Yeah, so if you look at the studies, Dr. Stephen Ceci, that's spelled CECI, his book, Jeopardy in the Courtroom, all of his studies conducted back in the 90s, Monster in the Box and Mousetrap and Sam Stone, genital conditioning, studies that were published on Dateline in 2020, it basically showed if the child could talk about the tooth fairy or Santa Claus, the child could talk about how daddy touched my pee-pee.
Right.
He did one study where, and this, I have this study on DVD where, the child is being touched lightly on the stomach and on the feet by a pediatrician with a pediatrician stethoscope
Right.
and a stick. And then when Dr. Cece's associate piggybacks the pediatrician and interviews the kid thereafter, this kid is 4, by the way, female. She said that the pediatrician hammered a stick into her vagina. There was no hammer present at all. And then, of course, that never happened. Clearly, that just never happened. So, it was a great study. And then, of course, I had a case where I was consultant on a little over 20 years ago out of Daytona Beach. And I referred the case to a forensic linguist, probably the foremost in the world. She passed away not too long ago, Dr. Ann Graham Walker. And the little child said, "Daddy put his pee-pee on my pee-pee." She was, again, 4, like the other case that was studied. And, obviously the authorities, everybody in child protection gleaned that this was genital on genital contact, pee-pee on pee-pee. But that's not what Dr. Walker, after doing her study and investigation, found that what the child meant was that daddy urinated on top of the girl's urine in the commode she forgot to flush. So this was a linguistic or language error that the system never picked up on.
Right.
And the guy was in jail here in Florida facing 25 years to life in prison at the time.
God.
And fortunately, we found this linguistic error before he took a plea bargain, before he went to trial in front of a jury.
That's a perfect example of like you said, how just a child's innocence and a child's language barrier of just being 4 years old and communicating, and then an adult will snatch that up and twist it out of fear or out of or being malicious.
Right. So everybody should know out there that CPS and cops are not experts. They are not expert witnesses. They are not allowed to give opinions in court. Okay? They are fact witnesses. There are 3 types of witnesses: lay witnesses, fact witnesses, and expert witnesses. And so, cases I've had of alleged shaken baby syndrome. Okay? I've had plenty of cases of those in my career. And, you have a situation where a child comes in the ER, and the typical scenario is about an 8-month-old child who has been crying and presents to the ER with bilateral retinal hemorrhages and bleeding in the eyes and a subdural hematoma and bleeding in the brain. And the ER doctor immediately upon intake gleans that it's shaken baby syndrome without
Right.
doing any genetic testing to see if the child may be suffering from what's called OI, osteogenesis imperfecta, or Ehlers-Danlos syndrome, or rickets,
Right.
vitamin D deficiency. So the thing, and when I get involved in a case as an expert, I'm trying to help the attorney, basically put in front of the judge or the jury that there are alternative hypotheses. There are other explanations for why the kid is saying what she or he is saying.
Hmm.
There are other reasons for why the medical expert is finding what he or she is finding. Very, very important. Alternative explanations.
What are a lot of the things that you run into with when you're getting into a parent that's making allegations or alienating a child? What are the behavioral diagnoses, whether we're talking about narcissism, personality disorders, anxiety disorders, depression,
Yeah.
trauma of some kind? Let's talk about some of
You're
the
talking
things that
about the accused. You're talking about the accuser.
the accuser,
Yeah.
whether you've ever dealt with Munchausen syndrome and
Oh yeah.
these
Yeah.
parents that
Yeah.
bring their
Yeah. I've
children
had.
to doctors for
Yeah.
all kinds of diagnoses that aren't real.
Yeah. I've had plenty of cases, and recently helped a mother here in Florida win a case actually in 2017. But let's take the John Mass case for example.
Yeah, let's talk about that.
My client who was murdered February 5th, roughly 10 weeks ago, in Lewiston, Idaho. I was hired in that case in late 2019. He had been through a custody battle where the wife had already accused him of raping her during the marriage, of domestic violence at a restaurant they had dinner at. He had video footage that was a false allegation of the domestic violence at the restaurant. He'd already been cleared of that. But when I got the case, child sex abuse allegations had already been made by the daughter, and then that was followed by the son.
Hmm.
And I mean, I found error after error after error. It was nauseating, and it was sad. And so, I worked with his attorney, and immediately tried to get the lawyer to file a motion for IME, which is a motion for independent medical examination or psychiatric examination of the accusing mother, who was suffering from a fixed and rigid belief system that the
Right.
child was a victim of sexual assault by her father, my client, John Mast.
No, I do have a question if I can interrupt you.
Yeah,
Is that because that was a trauma that she, in fact, lived as a young girl?
she was, in fact, sexually abused as a child and admitted that at her deposition under oath.
Yeah.
And what would be striking here is her father, who was John's assailant, the estranged father-in-law, who is in jail, of course, in Nez Perce County, Idaho, as we speak. He admitted under deposition himself, January of last year, that anybody who doesn't find John Mast to have molested his grandchildren is an idiot.
Mm.
So I pointed this out to the lawyers, and with all due respect to lawyers, they can litigate, they can file motions and petitions and argue the case in a court of law, and that's
Hmm.
about where it starts and stops. So
Mm.
they don't know a lot about science, and most don't anyway. There are a few out there that hold PhDs that obviously do.
Yeah.
And they are well-meaning, well-intentioned, and some are very aggressive litigators.
Right.
But they have to work with the expert, which in this case was me. That didn't go too well, and they, the motion for IME that was filed by John's North Dakota lawyer was denied, and that was very, very traumatic for us. It was very hurtful that we could not get the mother tested psychologically based on all the drama that she was creating around these children. And then, of course, she had unilaterally absconded with these kids from North Dakota to Idaho. So there was
Right.
really a child abduction involved,
Right.
also, which, of course, she didn't even get a slap on the wrist for that one.
Yeah. You said she
So,
already broke the law.
yeah, yeah. So, I mean, she was holding all the cards. She was clearly judge, jury, and executioner here. Well, anyway, to make a long story short, I testified in that case 11 months ago, last May. Fortunately, I was able to give clear opinions of what was happening in that case. That I thought the fixed and rigid belief system held by the mother, most likely held by the maternal grandparents as well,
Mm-hmm.
um, was metastasizing like cancer onto the children. So
Right.
this is known as F24 in our ICD-10, which is shared psychotic or shared delusional disorder. Significant persecutory ideations where the beliefs project from the parent, perhaps the grandparents, onto the children. And how do I know this? Well, I had the supervised visitation notes from the
Right.
kids with John, and they were horrible. I mean, I had never seen anything like this in my 25 years of working these cases. I mean, the daughter was saying, beware of the swayer, that
Mm-hmm.
her father was conning the kids themselves and her their mother and their grandparents and the system, and he was a con man, that he molested them and he got away with it,
Right.
uh,
But
or he was getting away.
no evidence whatsoever that could point him to the rest of his story being a con. There was not one thing that held up that was dishonest that they could catch him on.
Right. No, there was nothing there. John I had sent John to my doctor who does psychosexual risk assessment testing. He scored 10% on the cognitive distortion scale score, which
Right.
means he wasn't a con man, which means he wasn't trying to feign or hoodwink anybody. He was
And
being very frank
you
and
can't
candid with his answers.
manipulate you can't
And
manipulate those tests, can you?
right, and he showed no sexual interest to children whatsoever. His only interest was consensual relations with adult women. Period.
Mm-hmm.
And I testified to all of this, as well as the doctor that I sent him to testified as well. This was last May, 11 months ago. So sadly, that judge took over 6 months to make a ruling. His ruling didn't come in until December of last year, which is only 4 months ago.
Yeah.
John, and the lawyers kind of just stayed out of touch with me. That can't happen.
No.
You got to stay in the. You got to keep me in the loop the entire time of the litigation of the case, from the time I'm hired until the judge makes a final judgment. And that
Especially
didn't
because you're
happen.
the expert on the behavior that is perpetuating
Yeah,
during the
that did.
trial.
Yeah, it didn't happen. And John did a podcast like the one we're doing right now with Dad
Mm-hmm.
Talk Today
Mm-hmm.
in November, right before Thanksgiving. I didn't know about it. I
Right.
wouldn't have let him do that. I wouldn't have let him done that podcast because we didn't have a court order yet.
Right.
So why would you go in the court of public opinion before the court of law has ruled yet?
Right.
If the judge knew you did that interview, he might have been very ticked off. Well, maybe he did know, because he didn't give John much more than Disneyland dad visitation rights when he cleared his name of all abuse allegations in December of last year, 4 months ago. I didn't know John was seeing the kids on February 5th. I didn't know that the mother tried to get another ex parte 50B, as it's called in your state, DVPO,
Right.
domestic violence protective order again. I didn't know that was going on until I found out through one of the lawyers or the media after John was killed on February 5th. So I didn't know any of this was going on. The name is Dean, not Houdini.
Right.
And I'm not psychic, so you got to keep me in the loop on what's going on here.
Did they feel that the case was on the right direction, that there was no reason to keep you in the loop, or what happened?
Yeah, a lot of lawyers do that, and unlike a lawyer, I mean, experts only keep their eyeballs on the case file once every so often, right? Because when we're needed to help format and propose and fashion questions for depositions.
Mm-hmm.
We're needed when there's an evidentiary hearing to testify to findings and opinions, maybe to help impeach the credibility of opposing fact and expert witnesses at a hearing or a trial. And and then I guess the lawyers just think we're doing nothing with the case during the interim, and we're not needed. That's not true.
Right.
It's just not true.
Right.
And so So, for example, in any child custody or dependency case, I'm considered under Rule 615 3C as an essential witness, meaning a judge is allowed to exclude me from the rule of sequestration, where
Right.
I appear as both a consulting expert and a testimonial expert, both. So I'm helping the lawyer in real time on direct and cross and redirect and recross. And I'm also giving witness testimony, expert
Right.
witness testimony, both over the objection of opposing counsel.
Should the judge, like you said, it's ultimately what the judge decides. But when you're bringing in people like you who are these credible expert witnesses, shouldn't the judge really be leaning on your expert opinion?
Well, and
Or
judges
what's the
do.
point?
Judges do. The case law, Chris, differentiates on that from state to state. Judges oftentimes will abdicate to their own experts. Okay,
Hmm.
they will abdicate to the findings of a GAL, a guardian ad litem,
Yeah.
especially one who's court appointed. Most are, if not all of them are. I have a case right now where one came on that was not court appointed,
Hmm.
but she's trying to hover over the kid anyway. But yeah, I mean,
When is it?
judges are supposed to defer to an expert, although an expert cannot rule on witness credibility or the ultimate issue at bar. Whether you molested your kid, whether you abused your wife, whether you abused your kid, I can't say that.
Right.
I can lead that horse to the water. I can't make him drink it. That
Hmm.
is up for the judge to say.
When is a GAL necessary? And are they? Is it just a industry that was created to? Do we
Well,
need GALs?
yeah, most GALs, Chris, are lawyers. Okay,
Hmm.
there are some states where there are psychologists.
Right.
Um, and they're supposed to represent obviously the best interest of the child. They're also the arm of the court, so they're basically the judge in the field, looking over the best interests of the child. Obviously, they're a party to the case as an
Hmm.
attorney. So they get to object. They get to put evidence into evidence on the record.
Hmm.
They get to cross-examine. They get to do all that stuff. So they came to fruition in contested abuse and custody cases,
Right.
child abuse and custody cases. And oftentimes, even if a party does not file a motion to appoint one, a judge will sua sponte on his own motion appoint one anyway.
Right. So in your opinion, where do we sit? And I'm going to keep saying in your opinion because I want everybody to know that you're obviously an expert, but this is your expert opinion. And I don't want to offend anybody. Everybody has different experiences, but you've sort of seen it all. Um, what do we need to change? Going back to that question, what do we need to change in this system? What's broken
Yeah.
about it?
Yeah, so I think several things are broken, and it starts at the federal level, Chris, not the state level. You're not allowed to litigate, as far as I know. I'm not a lawyer, by the way,
Hmm.
so this none of this is legal advice.
Right.
To my knowledge, you cannot litigate for child custody in federal court, in U.S. District Court, because there are two doctrines. One's called the Rooker-Feldman doctrine, and one's called the Younger abstention doctrine, and they prevent litigation for child custody in federal court. So when you're litigating for custody, if you get an unfavorable ruling and then you are denied at the appellate court, and then you are denied at your state Supreme Court, you're pretty much toast.
Hmm.
You're going to have to stick with a modification of that custody ruling until the kids are 18.
Hmm.
But the laws need to change, starting with CAPTA, which
Hmm.
is the Child Abuse Prevention and Treatment Act from 1974.
Right.
Okay, that's the law that started mandated reporters, anonymous phone tipster calls. It gave CPS sovereign 11th Amendment immunity across the
Right.
board in all 50 states. That's
Terrible
got to
idea.
change. That's got to be repealed. We're talking what 50 years almost on that law.
Right.
That's going to be repealed. Then 20 years later, VAWA came to fruition. 18 USC 2265, the Clinton law.
Hmm.
Actually, it was the Biden law.
Hmm.
Biden co-authored that
He
bill
did.
when he was the U.S. senator.
He did.
So in conjunction with your 50B in your state, any statement of fear, threat, and harm, and she can hit you with a 50B with just hearsay,
Hmm.
and that's a no contact order for your kid by
And that,
proxy. By proxy.
yeah, in my situation, that occurred with no incident. It occurred after a breakup and after not having seen or spoken to my kids in 7 weeks. And I filed for custody for a hearing. I didn't ask for full custody. I was just filing for a motion to be heard. And 6 days later, I received a 50B, and I hadn't done anything.
Right.
And she dropped it, and
Well,
we
that
had
was
another kid.
yeah,
Genius,
yeah.
right here. Genius.
Back to the fire, right?
Yeah,
Um,
I you ignored the red flags, fellas. I'm not an expert like Dean, but I can tell you, don't ignore the red flags. Okay, believe them when they show you who they are the first time.
so we go from captive to VAWA from 74 to 94. And of course, this is the Violence Against Women Act. There is no Violence Against Men's Act. There is no
Yeah.
VAMA. And then 3 years later, we got the Clinton Act. That's what I call it, Hillary's Village Act.
Mhm.
1997, ASFA, the Adoption Safe Families Act, which basically perpetuated this stream of dependency cases across America. 500,000 kids in foster care, and mothers and fathers, especially mothers, losing their parental rights.
Has the
You know,
government disguised protecting our children with profiting and abusing us?
disguised it? I don't think
Have
so.
they made it look like it's protection?
I think it's pretty written on the wall. I mean, you've got Title 4D and E of the Social Security Act that filters
Sure.
in all the money, right?
Uh-huh.
Foster parents are getting stipends for taking kids from the
Mhm.
same government that's supposed to be protecting them. I can't tell you how many calls I've had over 25 years of working these cases back to 95, 96. You're talking 1,000 retained cases, probably 20 to 25,000 consults by phone or email or text or however people can get a hold of me.
Mhm.
But my point is, you get all these people, and they get knocks on the door from CPS on anonymous tipster calls, and I don't know what I did. What did I do wrong? And
Right.
next thing you know, you have a shelter hearing, you have a dependency hearing, your kid's taken, you're forced to sign a risk safety plan, which is that's been challenged constitutionally in Iowa by a lawyer, Natalie Kronk. I worked a case with her 5 or 6 years ago. And then you get the hoops you have to jump through with the case plan,
Oh yeah, and
and
it just drags it out.
then once the kid is in foster care for 12 to 15 months, bam, all of a sudden there's a petition for TPR. You're faced with termination of parental rights, and if a judge feels you have not substantially complied with that CPS case plan, you're toast. You're going to be TPR'd. And then, of course, you can appeal it, but good luck on that. Your chance of winning on appeal is like 2%.
Right.
So, it's nuts. And a lot of lawyers, they don't like to go up against CPS anyway,
Right.
because it's kind of like the government controlling the courtroom.
So Title 4 D&E obviously is what I'm familiar with. Violence Against Women's Act. And the others you had mentioned previously before Violence Against Women's Act was what, the Child Protection in 1969?
Well, that's captive, the Child Abuse Prevention and Treatment Act.
Okay.
And that's been modified a little bit since its introduction, but Trump put in the Family First Act. But I mean, the same mechanics and dynamics are working in these cases. Nothing's changed really.
Right.
And part of the problem is the burden of proof. The burden of proof for someone to get a 50B, the burden of proof for someone to get custody, the burden of proof for someone to prove dependency is all preponderance of evidence, 51%. More evidence than not. It's a very slippery slope. It's a very light burden, and that has to be augmented. That has to be increased to clear and convincing evidence, in my opinion.
Which is one step below what?
evidence beyond a reasonable doubt.
Beyond a
So
reasonable doubt.
right. So clear and convincing is the middle ground at 75%. Beyond a reasonable doubt is 95%. That's what the state needs to convict you of a crime and send you to prison.
Right.
So in order for Minnesota to convict Chauvin, of murder, they have to find beyond a reasonable doubt 95%, without a shadow of a doubt,
Mm-hmm.
and then there's sentencing. But and so the preponderance of evidence is the sticker, and that's the kicker, where a lot of judges, because of the word discretion that they have when they become a judge, they are anointed with that word discretion and that power. They can use that discretion to err on the side of caution, on the side of the kid, against the accused, and oftentimes they do so.
The older I get, and I'm almost 39, the more I see that government uses our safety and the best interests of everybody to be abusive. What do you think?
Well, they can. It boils back down to Hillary's village, and in loco parentis, parents patriae, the state is the parent. And I mean, I told you about that recent case I was on. It was a year and a half ago, Daytona Beach. I was helping a mother, and the state of Florida spent about $300,000 to try to terminate her parental rights, and we were at trial. I was there at trial for one whole week. In the what the judge tabbed the expert week, if you will. And so I was there to help impeach the experts against us,
right,
while I also gave testimony. And that trial took 4 months, and we won. I mean, and not only did we win, 4 people were fired. 4 people were fired on the side of the government at the end of that trial. Two caseworkers, the director for the DCF in Daytona Beach, and a lawyer representing the DCF against us. They were all fired, and that's what happens when you don't win for the state.
Right.
I mean, it's Mike Tyson time. You're there to get results,
right?
And if you don't get results, you're going to be Donald Trump. So that's what happened there. That's what happened there. So. But a lot of work. You got to understand, Chris, in these cases where I try to help a lawyer intersect the facts of the case with the law and the science, you connect those 3 dots in court. Oftentimes, you'll be successful. You got to roll up your sleeves and do the work,
right?
And that doesn't mean you can gloss over the case file and miss fine points. You have to read the file, just like you were reading the Bible, the Scripture. You can't miss anything,
right?
I'm not blaming John Mass lawyers, to go back to his case real quick, for obviously leading to his demise, but clearly there were missteps in his case.
Sure.
And John made a few of those missteps himself.
Do the courts really know? So the courts err on the side of caution when it comes to an allegation, but it doesn't seem to err on the side of caution when it comes to proven false allegations, proven lies, proven abuse, proven manipulation. And what they should have done was given John full custody immediately. This woman should have been psychologically evaluated.
Yeah, that didn't happen.
So they're not erring on the side of caution on the right side.
That was our goal, obviously. I mean, I always ask a client when I'm hired, what do you want out of this case? What are you looking for? Are you looking for joint custody, sole custody? Obviously, you're looking to clear your name of the abuse allegations. That comes first. But in John's situation, the court took way too long to rule. Obviously, over 6 months, that can't happen. The lawyers did try to press the judge. I don't know how much they pressed him. I don't know if they could have done anything differently. I'm not a lawyer, but I think they could have. They didn't, and the judge took over 6 months to rule.
Right.
That perpetuated the mindset of the kids with this fixed and rigid and false belief system that their father did something and he got away with it. Beware of the swayer. And let's not forget the word memory.
Right.
Memory is not a perfect videotape. It's one of the areas I testify in, and what happens, with these false allegations, a lot of them, anyway, you develop schemas. So a schema is an enzyme or protein that can help alter or modify memory. And so the explicit memory is controlled by the amygdala and hippocampus, and now that has taken over your spontaneous memory, which is controlled by your prefrontal cortex.
Mm-hmm.
So the explicit memory is the one that is vulnerable to contamination and taint. And so when you get a well-meaning, well-intentioned therapist, and certainly John had one who was against him, who already suffered from confirmatory bias and had a preconceived notion, he molested the kids.
Right.
So the kids were actually treated by a mental health counselor as if they were molested. Now, judges are trained a lot in these cases that if a custody battle ensues and there's an allegation of abuse, just because of timing, where a child can be used as a pawn, weapon, or tool for the purpose of getting custody and child support and social status as the most fit parent, that it must
Right.
be a false allegation. Well, my first book was published almost 30 years ago, Don't Blame Me, Daddy, in 92.
Mm-hmm.
And while I talk about that in my book, I also talk about the fact that real abuse can happen in custody battles, because it does.
Mm-hmm.
A kid can be molested within a custody battle. A kid can be physically abused within a custody battle. Obviously, we know kids can be alienated within custody battles.
Right.
Happens all the time, all the time. The most egregious and acute form of alienation is the false allegation of abuse.
Mm-hmm.
And oftentimes I will try to, compel attorneys to force a court, try to force a court to make a finding of fact, conclusion of law that the abuse allegations were false or unsubstantiated. Very, very, very important.
Right.
And you just can't gloss over that, because a judge can always fall back on that, because that abuse allegation, if a judge doesn't make that finding of fact, conclusion of law that you did not perpetrate abuse,
Mm-hmm.
is one of the best interest factors that can be used against you. Just go look at your North Carolina general statute on the best interest factors of the child.
Right.
And you'll find one on abuse and neglect of a child.
Sure. Let's talk about what we were talking about misconceptions of abuse versus, and we didn't really go over this other than there's a few misconceptions about men being the primary abuser and statistics and this and that. So what is your knowledge about, let's just talk about what really is happening, what we know from data science, not what culture tells us, not what the news is showing
Right.
us.
Yeah. So of course this is April Child Abuse Month, and
Yeah.
CPS runs a lot of public service announcements on billboards and radio ads across America that 1 in 3 girls are molested, or 1 in 5 boys are sexually abused, and that's not even anecdotal. It's
Right.
not even anecdotal data. It's clearly not empirical science.
Right.
It's ideology, in my opinion.
Right.
And it's propaganda to get you to think that, oh my gosh, we have a huge child protection problem in this country. And I guess you could say that's part of socialized medicine and socialization of this country. And certainly, I think most of the child protection efforts and the money that's poured in for the same come from the Democrats.
Sure.
Okay, and so I think they go hand in hand. Kamala Harris, our vice president, was a sex crimes prosecutor in California, in Frisco.
Mm-hmm.
Obviously, Joe Biden was a U.S. senator in '94 who co-authored the Violence Against Women's Act.
Right.
So we're all about protecting women and children, but men and fathers are on the distant horizon. I've been at this now for 35 years, back to the mid 80s. I haven't seen a lot of momentum, if you will, on behalf of men and fathers.
Right.
We've got some scientific studies. We've got some books. We've got, obviously, anecdotally, I have cases that I've helped to win.
Right.
I probably have, I don't know, a dozen fathers in this country probably have sole physical legal custody in part because of yours truly.
Mm-hmm.
But we really haven't made strides forward to like California, initiate statutes and laws where we have presumptive joint physical legal custody.
Right.
Everybody promotes shared parenting.
Right.
Well, I can tell you in my practice, there's nothing shared about shared parenting.
Right. I'm sharing. I'm in shared parenting. I'm every other weekend. I'm shared parenting.
So it's not really shared parenting.
Right.
It's Disneyland dad visitation rights.
Right.
That's what
Exactly.
that is. Or it's
Garbage.
Disneyland mom visitation rights.
Sure.
So unless a parent has been proven to be in court abusive, neglectful, or has abandoned the kids, or is unfit, it should be presumptive joint physical legal custody, 50-50, right down that 50-yard line.
I agree. I know that Texas is working on that right now. I know Arkansas just passed theirs. We know that Kentucky has one passed. The only thing that some other experts of friends of mine and stuff within the shared parenting movement, or whatever you want to call this movement, have sort of that preponderance of evidence that they didn't have the evidentiary standard high enough if there's any issues. So, that can always be something that's used with false allegations.
Yeah, and the legal climate and the legal arena, Chris, is very much against augmenting the legal burden of proof from preponderance of evidence to clear and convincing. Very, very much against that.
Now, Arkansas did get clear and convincing evidence, which was a huge step up from Kentucky's bill.
Yeah, that is absolutely
that's a home run.
That's what you wanted. Yeah, and certainly, but because you can't litigate for child custody in federal court, you're not going to see that law come from Washington D.C. From the federal government, right?
Right.
So every state has to individually replicate Arkansas.
Right. Right. And one of the good things is some of these states are going to follow suit, but the more states that do this, the more, just like with Kentucky, we have things that we can show, from lower domestic violence, lowered litigation, lower, all sorts of statistics that have been affected by, as the years pass. Kentucky's has been passed since 2018, and their domestic violence has gone down, litigation has gone down. The courts are not as tied up with meaningless litigation. And a lot of domestic violence that hasn't occurred actually does occur because of custody battles. We are legalizing the theft and kidnapping and extortion, I like to use these words, of our children, but do you feel we've normalized this as part of culture? Like, we're not taking our offspring and getting money for it and buying them back and trading them, and have we normalized this?
I mean, as far as custody litigation,
yeah, have we normalized this industry as it's acceptable? Like, it's a poor, in my opinion, it's poorly set up.
Well,
and they know
in my state of Florida, there was litigants are required to enter into mediation before custody litigation. So there has to be attempted mediation. Do you have to execute mediation? No. Right. And certainly if you're a parent with borderline personality disorder, your mental health behavior patterns and the chemical receptors in your brain will not allow you to do so, because you're thinking black and white, splitting. So you're thinking protracted contested litigation.
Literally, I dealt with, in my mediation, and just to give you an example, a young lady that said that, right now I have every other weekend, and I get offered the kids whenever she wants time off, or the kids have spring break or whatever. I can take them for 4, 5, 6, 7 days at a time, but literally told the mediator that I'm not mentally, emotionally, financially fit. She said, well, he lives at his dad's, but meanwhile I pay her hundreds and hundreds of dollars a month so that she can afford her own home. So it seems like someone with logic, like a judge or somebody, would be able to tell this young lady, the things that you're saying are illogical. You're allowing him to be around his kid whenever you want a vacation, time off. You're not feeling well. You have to work, and you're giving your child to your other, their father or their mother.
Right. Right.
But you're going to testify in mediation after you've behaved this way, where you're willing to give them and say he's not fit or she's not fit.
Well, she can't say that. That's an ultimate issue at bar. Issue Rule 704 for the court.
Right.
Clearly, the province of the court. But beyond that, she's not an expert. So
No,
she hasn't done a mental status examination, clinical interview, or psychometric testing on you.
the mediator. You mean?
She probably. What's that?
You mean the mediator or
Well,
my ex?
either or.
Sure.
Either or. Mediators are lawyers.
Sure.
So what do they know about mental status examination, clinical interviews, and MMPI-2s and MCMI-4s? They don't know anything.
Right.
So they're lawyers. So, and a judge knows that. And so a judge has to put his or her fist down on that one.
Yeah. Yeah, that's what you hope for. So going back to the misconceptions and the cultural narratives that are false. For instance, the big one would be, off the top of my head, is the ratio of domestic violence between men and women, where obviously culture would say that men are more physically abusive and typically are abusive in a relationship. But we know, I've learned that that's actually not true at all. And then it's closer to 50-50 than you'd think.
It is. Yeah. If you look at the even the Strauss, Steinmetz, and Gelly studies from 25 years ago or more, it was 50-50 on women to men. Certainly on child sex abuse, it's much more men that are accused and go to and convicted.
Well, they don't accuse young women who, young teachers who have sex with their students. You know what I mean? A lot of these teachers don't even get fired. I've seen tons of stories where, these young ladies, these 23, 24-year-old women have these sexual encounters with 16-year-old boys. That's statutory rape.
Well, Mary Kay Letourneau. Mm-hmm. You may not be old enough to know that case, but that was back in the 90s, and she wound up impregnating, the kid, a
student of hers.
Yeah,
I do remember that.
Yeah, so they had a kid. I don't even know. She may still be in prison. Washington State. I believe that case was born out of Washington State. Mm-hmm. There's been a bunch of them, but it's rare when you find a mother who's accused and arrested for child sexual assault, or even goes into dependency court against CPS for child sexual assault allegations.
Where are the biggest, and I believe I know the answer, but I want to ask you and see if we line up with that. Where are the biggest situations where child abuse takes place?
Well, most children, almost all cases in child sexual assault, the victim knows the perpetrator. Right. So either it's an uncle or it's a grandfather, or occasionally it's a father. That's more the exception than the rule. It's a boyfriend, or the stepfather would be more the rule than the exception.
I've heard that is the highest rating of abuse taking place is usually the mother's new spouse, boyfriend, right, husband, stepfather, right, whatever. Where it's like 70% of these sort of abuses, whether it be sexual or physical, is right, the new man that's not the father of the children.
Right. And to go back to your earlier talk about the issue on the ideology, and this is Child Abuse Month, mm-hmm, and the numbers, these statistics. If you go to my website, abuse-excuse.com, right on the homepage, there's a study there by Dr. David Finkelhor from the National Center for Crime Against Children, Durham, New Hampshire laboratory. He did a study from 92 to 06, 15-year study, and he found the incidence of child sexual abuse decreased by 50%. So mm-hmm, the number of reports stayed consistent at about 3 million a year for the country. This was published in Child Maltreatment, which is the journal that supports NCAN's National Center for Child Abuse and Neglect data systems. So he did a study and he found the incidence of child sexual assault actually decreased by 50%, but the numbers remain constant. Well, if the numbers remain constant, what does that tell you?
Right.
There's got to be a plethora of false or unsubstantiated allegations. Now, there's been a few studies where the false allegation numbers have hovered between 2 and 10%. Going back to Thenis and Jaden, 1989, they did a study that did not have a large sample size, but they did one. And across the country, most of these organizations like RAINN, if you Google RAINN, RAINN.org, that's a rape and incest survivors network. They'll tell you that most false allegations hover around 5%, between 2 and 10%. But that's not the real thing of what's going on here. What's going on here is most of the numbers are unsubstantiated.
Right.
Most are not malicious lies, but most are mistakes.
Right.
Unsubstantiated mistakes. And those numbers hover around 70%. And so, you take that with the false numbers. Now you're at 75%, and you don't have more than 1 out of 4 that is going to be substantiated or confirmed, or is an actual case of sexual assault. So they're not high, but of course they do exist. These numbers. I don't like to battle numbers because they don't tell the entire picture.
Sure.
Okay.
Sure.
And so we could battle numbers all the time, but the reality is, Eugene Koenen did a study and found 40% of his study test subjects were false allegations of sexual assault, adult sexual assault. Cases like Bill Cosby, Harvey Weinstein, Jeffrey Epstein, Deshaun Watson, the quarterback for the Houston Texans. He hasn't gotten arrested yet.
Right.
He may, but that was just one study. So it's a very, very divisive issue. You have he said, she said, and they said, and everybody else in between.
Should we stop having kids, Dean? Should we stop having kids for now? Should we tell our children? Should I tell my boys not to have kids right now?
Thank God for body cams, and thank God for.
You told me to get one.
Yeah, thank God for some type of accountability. You just have to have eyes behind your head, and you have to be cognizant that you are one accusation away from a nightmare,
right?
Where your entire world can be, turned upside down in a New York minute,
right?
And so with that said, I've had cases that have gone into 7 figures. I had a case, that went to 7 figures, and my client was a board-certified gastroenterologist, and he was up against the mother, who was a board-certified psychiatrist. And fortunately, we were able to get the psychiatrist to see a psychiatrist.
Wow.
But
that doesn't tell you something right there. You got a lot of experts that need expert help.
Yeah. So that case was a nightmare, and the mother hired 4 of the foremost experts in child sexual abuse in America. That I wound up having to help one of our attorneys format questions for depositions of all of them.
Right.
And so that was a decade ago, and we won that case. He wound up with sole physical legal custody. She didn't stop after he moved from California back to his home state of Arizona. She continued to falsely accuse him, and finally, the judge from Arizona just cut her off at the knees. Look, COVID has obviously backlogged litigation in court, where pretty much everything goes by Zoom, and what kind of due process are you going to get over a computer screen? Right. Imagine you're at a criminal trial, and your experts trying to make eye contact with the 12 or 14 jurors. How does that happen over a computer screen? It doesn't. So there's a due process issue there to be very concerned with. And then you have lawyers who play the let's wait and see what happens game.
Well, there is a due process issue in family law, period. Like it doesn't exist really. Period.
Well, I mean, you hope it exists. It's the 14th Amendment. It's Rule 403. It's Rule 404B. You have to. And look, I tell all clients because I wind up having to sometimes have to babysit attorneys. You got to do the same. You got to check all the statutes, check the case law, check the pleadings, make sure they're legally.
When you question an attorney, depending on the attorney, and I can tell you that 3 of mine so far don't like to be questioned, they'll just drop you.
Yeah, well, the judge has to order a counsel. If counsel files a motion to withdraw as counsel of record, the judge has to order that where counsel has been withdrawn. So you can request a hearing on that.
Mine was withdrawn without a hearing. It was just approved.
Very unusual.
There's all kinds of laws being broken in all kinds of places in this country.
If you requested a hearing, that's unusual. But
I did not request a hearing. I let that one go because that attorney, after being paid in full and getting to the trial, we had to continue it because it was the end of the trial week, and the judge said, "Well, let's pick a date in the next month or so. You 2 attorneys get together, and this will be the first case calendared on that trial week. We're going to get it done." Well, 6 days later, I asked my attorney, "So have we come up with a date?" And they told me, "We just noticed that your $10,000 retainer has run out." Meanwhile, I've never been sent any sort of weekly, biweekly, or monthly totaling. And we're going to need another $10,000 if we're going to move forward. So when I disagreed with that attorney and asserted myself, they withdrew.
A lawyer, Chris, can argue just like a divorce petition. Man and woman, man and wife are arguing irreconcilable differences. A lawyer can argue there's been an erosion of the attorney-client relationship.
Meaning I abused them and they don't like it, so I'm leaving now.
Yeah, and I mean,
no accountability.
Yeah, so at a contested hearing for withdrawing of counsel, I don't think I've ever seen a case where a judge has not approved that. So if you're at a point where the lawyer is going to file that motion to withdraw, you pretty much lost that lawyer.
Sure.
But with that said, if the lawyer does that a week or 2 before a hearing or trial, usually that won't be granted because the judge understands it's too late for you to get a new lawyer to get up to speed. If the judge does grant this, certainly you're going to have a continuance.
Yeah, clearly we were at trial and we were moving forward. We just had to continue it. And to hit me up for another $10,000, come on now.
Right.
So, when the time comes, that person will be revealed as well. But right now, my focus is my children.
Chris, my website's up to what, 1.1 million hits, I think it is.
Yeah.
And look, over 25 years, if you do the math on that, I don't know what that averages out to, but my point is these allegations don't take a holiday. So when I get involved in a case, I try to persuade the attorney. I cannot force the attorney to do anything. I can only suggest and recommend and persuade, right? So I try to persuade the lawyer to work the case as quickly as possible to a resolution, not only in the best interest of the child victims, because certainly the child is a victim, whether the child's been abused or not abused, and the child is a non-abused child who's being treated as a truly abused victim. It's still the child's a victim.
Right.
But to get this case to trial and get it over with as soon as possible, because by God, I got another case coming down the chute. I got 22, 25 cases on my plate right now. It just doesn't stop.
And the longer you drag it out,
there aren't a lot of people out there that do what I do. I wish there were more.
Yeah. Maybe we need to look into that. Maybe you need to build up a squad. You want me to be a squad leader on your squad?
Yeah, well, I mean,
I'm sick of this, man. This is ridiculous. This has ruined my life, at least the last few years of it.
Yeah. Nobody wants to go through this during their 20s, during their 30s, 40s, or
No, I should
you
be
know,
having fun with my kids, and me and her
right,
should be learning to grow
right,
separately and have a friendship. And this is ridiculous.
right. So a lot of the problem, Chris, lies in that preponderance of evidence, legal burden of proof that has to be increased to clear and convincing. A lot of the problem deals in hearsay. We have to put a vice grips on hearsay, a tighter vice grips on hearsay, and what can actually can be introduced as hearsay. We have to re go back to the drawing board and redo those exceptions to the hearsay rule.
Right.
Uh, there's too much leeway from these mandated reporters to turn you in because they have a reasonable suspicion of child abuse
Hmm.
within their sole discretion of what is child abuse.
Hmm.
And now the government's getting involved, and now the behemoth CPS is breathing down your back, and the police are ready to show up with lights and sirens on.
Hmm.
And the next thing you know, you're, as I say in chapter 14 of my book, Elusive Innocence, you're in the three-ring circus. You're in juvenile, family, and criminal court, and your lawyer is only skilled in criminal court. So what
Right.
are you going to do there? Now you got to hire multiple lawyers because
Right.
your lawyers don't know how to litigate all three venues.
Exactly. Well, Dean, it is about that time. Um, of course, I'm going to have you back. I like having you back periodically because I could talk to you all day about all kinds of stuff.
Yeah,
But it
yeah.
is
Unfortunately.
April. You are with me on April, and I want to talk about this is your month. This is your month because this is what you deal with. This is your profession. Um, what can you tell? What message would you give parents like me, parents like my ex, judges, attorneys, legislators, adults, grown-ups? What message would you give with all your experience? Give them something for this month, please.
Well, I think the message is obviously you have to put the needs of your kids ahead of your own.
Hmm.
So certainly, children are our most precious resource,
Yes.
and we have to always put children first. With that said, we don't need to create cases. We don't need to create litigation and create court cases, and we don't have to basically help the government because we're asserting hearsay
Hmm.
at the local bar, and that turns into an allegation, which turns into an investigation.
Right.
So I think there's enough investigations, certainly for the police. They don't want any part of this child abuse cases. They don't really
Right.
want any part of of dealing with those investigations,
Hmm.
other than maybe sexual abuse,
Hmm.
physical abuse, real physical abuse cases. So yeah, we need to get back to trying to work things out as a family unit. Get back to the family in this country, which means we got to try to work things out mediation wise and not litigation wise.
Right. No, I agree. I agree. Do you have any advice, or have you ever worked on any legislation?
Yeah. I got some. I was successful in the '90s getting some laws passed here. Our malicious false child abuse allegation law 39205 subsection 9, which I had texted you.
Hmm.
So in Florida, in my state, if you maliciously falsely accuse somebody of child abuse, you can go to prison for 5 years.
What is maliciously?
Well, maliciously would be perhaps there was proof that you through text message or email or post on social media you were going to get somebody,
Hmm.
you know how to do so, and then you followed through with that intent.
Okay.
So bad faith, premeditated forethought. You were going to make sure this person wound up charged with lewd and lascivious
Hmm.
child molestation or capital sexual battery, as it's called in my state of Florida. Either or is punishable by life in prison without parole. You're done.
Right.
So very serious. Um,
You said what is a felony 3? So it's a felony 3 to make malicious false allegations.
that's correct in Florida.
And
And,
what
and
what is
I'm
the
gonna I'm
penalty
gonna
on?
I'm gonna say I'm gonna say there's 4 or 5 states in America that make it a felony. The rest, it's pretty much a slap on the wrist.
Mm-hmm. Like,
Yeah.
don't do that, or you'll find yourself in trouble next time.
Well,
Maybe.
the police will tell you we don't want to arrest somebody who's a false accuser because it places a chilling effect on those women and children who would report in the future.
Okay. All right. So we need to figure out a better plan to protect both sides.
Yeah, and the sides, like I said, in the tennis match, it's very tilted, advantage system, advantage allegations.
Sure. Right, because erring on the side of caution is always
Well,
the smart play.
it's also erring on the side of investigations.
Sure.
Because of my presence in Florida, at least, they've been a little hesitant to do investigations when there's a known child custody battle on the table,
Mm-hmm.
and there are allegations. They've have a tendency to screen those out because they know we might be used as fish bait here. CPS, that is. We don't want to be used as fish bait. We have better things to do.
Yeah. Well, I want to pull up your website here one more time. That is abuse-excuse. .com. And this is Dean Tong's website. Dean, are you currently hectically busy? You want people to be calling you right now, or where they leave a message?
Well,
they call your house?
It's 11 o'clock at night, so they better
Don't
not
call
be
Dean
calling
right now.
me. Yeah. But I
Unacceptable.
mean, yeah, you can email me. Obviously there's a form. If you go to where it says interactive, there's a consult button under the interactive button.
Yeah, let's
So
follow that.
there's an accused questionnaire form right at that consult link, and you can tell me your story. There's a bunch of questions there. I would ask that you try to answer to the best of your ability, and I will email
Like,
you
what's
back.
your real full name? They better get that one, or you're not taking
Well,
them
no,
on.
I mean, no, you can remain fictitious in a pseudonym until you
Sure.
hire me.
Yeah.
When you hire me, though, on the retainer agreement, I have to know your real name. But
Absolutely.
no, but I will email you back. There's no charge for that. A lot of people do fill out that form. I try to do the best I can with giving advice within my area of expertise. I cannot give legal advice. I'm not a lawyer.
Right. Well, Dean, thanks for coming on again. I want to do this again soon. We'll get you on maybe in another 9 episodes and keep bringing you on. But it is Parental Alienation Awareness Day coming up on the 25th. I have a special guest on the 25th. It's actually the mayor of my city, because we just got that declared. I just picked that up today, that proclamation, that in the city of Burlington, North Carolina, it's going to be known as Parental Alienation Day on April 25th moving forward. So,
let me suggest, Chris, in the future, you try to interview Dr. Jennifer Harman.
Sure.
Harman. She's out of Colorado.
I will reach out to her.
Yeah, probably the up and coming expert, if you will, in this field across America.
I've seen her videos. I know she was on with MPO a few times. I know she was on Dad Talk, and I'd love to have her here and have a conversation with her as well. So I will reach out to her probably this week and see if we can get her on maybe next month. So that's a great suggestion.
Yeah, nobody better on the science than her.
Well, Dean, thank you so much for your time, for your expertise, for your just being real humble to come on a no-name podcast show like this. Trying to build it up, trying to ask the right.
You're doing a great job, and it's a privilege to be on your show. Thank you.
Thank you, Dean. Have a great night, everybody, and we'll see you next time from We the Parents.
Thank you.
Bye now.